course, we do legal analysis and education here at Law Self-Defense. So I actually have a little PowerPoint slide. I think I have a little PowerPoint slide. I do. Now, for those of you who are listening to this in, let's see if I can change this up a little bit. Yeah, I think that'll work okay. Listening to this in audio form, podcast form, I've got a little visual set of slides here. They're not complicated. I'll just also describe them verbally so you can have a sense of what's going on. Imagine a continuum of thresholds of evidence from left to right. It's a horizontal bar. And at the far left end, it's 0% evidence. So there's zero evidence of anything having to do with criminal misconduct, criminal behavior. Zero evidence. At the other end of the spectrum is 100% evidence. Absolute certainty that this defendant committed the crime as charged, right? That's the continuum. A minimum of 0% of evidence and a maximum of 100% of evidence. And along this continuum, our criminal justice system in America establishes certain defined, sometimes well-defined, sometimes poorly defined thresholds of evidence. Let me see if I can. One of the most common thresholds of evidence is preponderance of the evidence, and that's simply a more likely than not standard. Is it by the majority of evidence, is something proven or not proven? And this is the normal standard in a civil trial, for example. That's all that's required. Somebody alleges some kind of tort, some kind of unjust conduct that resulted in damages. They don't have to prove it beyond a reasonable doubt, like the state has to prove a crime in a criminal prosecution. A plaintiff in a civil case generally has to prove the claimed misconduct and harm by a preponderance of the evidence, meaning 50% plus a hair, and it's decided that's what happened. And if it's 49.9%, it's decided that's not what happened. Now, when a jury typically is making that assessment, are they saying with absolute certainty, 0% chance it happened or 100% chance it happened? No. We just had the trial with Kevin Spacey, right? Some kind of sexual assault trial he was in, and the jury found against the plaintiff. Somebody was suing Spacey for sexual misconduct. The jury found against the plaintiff. That was a civil trial. The legal standard is preponderance of the evidence. The jury found against the plaintiff and for Kevin Spacey. Does that mean that the jury believes there's zero chance that Kevin Spacey sexually assaulted the plaintiff? No. They might think there's a 49% chance that Spacey did that, but that would not be sufficient to achieve the required threshold of evidence in a civil suit in order to find that the plaintiff had won, that the plaintiff had proven their case in a civil court to the necessary threshold of evidence, which is a preponderance of the evidence. All it means is that the jury was given this threshold and said, you have to decide if it's 50% over and a hair, then you find for the plaintiff. And if it's a hair below 50%, you find for the defendant. And that's what they did in that particular case. But there's no certainty, right? There's no 0%, 100%. It's floating somewhere around there in the middle. Now, I guess you could interview the jurors and ask them, maybe they did think it was 0% or 100%, but you'd have to ask them. Their verdict alone would not tell you that. So that's preponderance of the evidence. On a very, very low end of the spectrum, we have a threshold called reasonable suspicion. And it means pretty much exactly what it says, that somebody has a suspicion, not a high degree of certainty at all. A very low degree of certainty, so low a degree of certainty that it's a suspicion. But the suspicion has to be reasonable, meaning it can't be based on some speculation, particularly in our case law in the U.S. on some kind of like racial speculation. You see someone with dark skin in a white skin community, you can't just assume they're there to commit a crime, for example. There has to be some articulable set of facts against which you applied your powers of reason to develop this suspicion. And this is what's required for an officer to stop you, for example, and ask what the hell you're doing there. And how might this arise? It might arise because someone's been robbing cars in their neighborhood, dressed in a particular way, and your dress matches that description. Does the officer know that you did something wrong? Does he even have even a 50% belief that you did something wrong? No, not yet. But he can have a reasonable suspicion, a suspicion based on the fact that your dress matches the dress of someone who has been robbing cars in the neighborhood. That's the reasonable suspicion he can use to stop you and basically conduct an ad hoc investigation right there. Who are you? Why are you here? What are you doing here? Things along those lines to try to flesh out that suspicion into something greater than merely a reasonable suspicion. And by the way, one cliche in the law, especially the criminal law, is if you're in a car, there's almost always something. There's almost always reasonable suspicion. I would argue there's almost always probable cause, but it is kind of a cliche. On the other end of the spectrum, we have a concept we all know, of course, beyond a reasonable doubt. This does not mean 100% certainty. This is part of the reason why it's possible for the most innocent defendant to be convicted, 10% chance of conviction at least, because the jury's not required to be absolutely certain that the defendant's guilty of a crime. They need to be certain beyond a reasonable doubt. They could have some slight doubt and still find you guilty. They don't have to have absolute certainty. So beyond a reasonable doubt is not 100%. In fact, it's not any specific percentage any more than reasonable suspicion is some particular percentage on this continuum. Whenever a judge tries to help a jury and define for the jury, suggest a particular percentage for beyond a reasonable doubt, and they might say, well, it's 90% of the evidence or 95% of the evidence or 98% of the evidence, they always get reversed because the appellate courts don't like this. They want the concept of reasonable doubt to be whatever that particular jury decides it means, with no further guidance from the court, except to the extent that, again, just like reasonable suspicion has to be the suspicion has to be the product of reason, not speculation. Whether or not there's a remaining doubt also has to be reasonable. The application of powers of reason to evidence, not merely a speculative doubt about whether or not the defendant is guilty. You have to be making a reasonable decision here. That's what beyond a reasonable doubt means. But other than that, the courts generally simply define reason beyond a reasonable doubt by using the words beyond a reasonable doubt, which perhaps not super helpful, but that's the way we do it. Then we have another standard. It doesn't come up too often in criminal law, but there is a particular circumstance, which I may talk about more tomorrow, in which it can come up. And that is something called clear and convincing evidence. And the truth is, we don't really have a great definition for what clear and convincing evidence is, except that it's not as high a threshold as beyond a reasonable doubt, but it's a higher threshold than a mere preponderance of the evidence. So it's somewhere ranging between that 50% and whatever you think beyond a reasonable doubt is, 90%, 95%. But it's a very vague, ambiguous legal standard. And the most common place we see it applied today in criminal law is in the state of Florida. Florida has a legal doctrine called self-defense immunity. Self-defense immunity is best thought of as kind of accelerated, time-efficient, cost-efficient, pre-trial way to arrive at a finding of self-defense justification without having to go to a full-blown trial. A defendant can demand a self-defense immunity hearing, what's often mistakenly called a stand your ground hearing in Florida. And if the defendant does that, then the state in that hearing has to disprove the claim of self-defense by clear and convincing evidence. Now, once the case goes to trial, if it goes to trial, then the state would have to disprove a claim of self-defense by beyond a reasonable doubt, a higher threshold. But at the pretrial self-defense immunity hearing, the state's threshold is lower than that. It's clear and convincing evidence. So they might be able to disprove self-defense immunity, disprove self-defense at the pretrial hearing by clear and convincing evidence, which would deny the defendant immunity, and off to trial he would go. And the state could, even though they've met the threshold of clear and convincing evidence, they could still fail to meet the threshold of beyond a reasonable doubt, and that defendant would be acquitted. But at least with the self-defense immunity doctrine, where the defendant has a strong case of self-defense, they have a prospect for having self-defense adjudicated, a court finding of self-defense and a dismissal of the charges and immunity from prosecution and civil suit. in that much less costly, much less risky pretrial setting than in the full-blown trial. But again, clear and convincing evidence, kind of a vague, unclear standard, not well defined. Now, what about probable cause? Where on this scale should we put probable cause? In other words, how much evidence on this continuum from 0% to 100%, how much evidence should the state be obliged to present at a pretrial hearing in order for a judge to agree that you should be subject to criminal prosecution on that charge? And I've always believed that the appropriate standard here, when we're making this probable cause assessment for the purposes of going to trial, is that the threshold for probable cause should be identical to that of preponderance of the evidence. It should be right at 50%. And I think the support for that is not only sound on public policy reasons and on reasons of law, but it's in the phrase itself. Probable. Probable cause. Probable means more likely than not. I would argue. But is that where our legal system, our modern American legal system today, places the threshold for probable cause? Is the state actually required to present to the court or to a grand jury a majority of evidence, a preponderance of evidence that you're guilty of the crime before you can be dragged into a criminal prosecution? The answer is no. The state's not required to meet anything like that threshold of evidence. In fact, the threshold they're required to meet is some undefined level of evidence that's substantially less than preponderance of the evidence. It's more than reasonable suspicion, but it's less than preponderance of the evidence. And I think that's wrong. And this plays out in a few different ways. If we're talking about this kind of probable cause hearing, as we'll see, the judge wrote in his decision here, his 11-page decision that we'll step through in a moment, the judge is basically saying, if there's any view of the evidence that's consistent with guilt, any narrative of guilt that the prosecution can present that has any support in evidence, that's sufficient for probable cause. So you could imagine that might be 25% of the evidence supports the claims of the prosecution. And that would be sufficient for this judge to proceed this defendant to criminal prosecution. I think that's wrong. I think it's especially wrong when everyone knows that at the trial itself, the standard's going to be that the prosecution has to prove guilt beyond a reasonable doubt, which is an enormously higher threshold than preponderance of the evidence and much greater than the current standard for probable cause. My feeling is that if a prosecution cannot show 51% evidence at a probable cause hearing, they ought not be given the opportunity to try to gin up the 95% of evidence that's required for a guilty verdict. The defendant ought not be subject to that risk. And in the context of we're not talking about a probable cause hearing, but we're talking about a grand jury indictment, I mean, it's even worse because for grand juries, they're really only told one side of the story. They really only hear the prosecution's side of the narratives. Remember, there's always competing narratives, right? There's a narrative of guilt that's crafted by the prosecution, and there's a narrative of innocence that's crafted by the defense. So there's these competing narratives. And in the trial itself, those can be completely argued on both sides, in theory. But for the grand jury purpose, to determine whether or not there'll be an indictment and an accused gets dragged off the trial in the first place, the grand jury only hears one side of the argument. They only hear the prosecution's narrative. And we all know if you only hear one side of an argument, it sounds pretty compelling. That's why trials themselves are an adversarial process. And frankly, grand juries should be more of an adversarial process. Now, in this pretrial hearing we have in this case, this probable cause hearing, it was more adversarial. Both sides were allowed to argue to the judge. The judge acted as a finder of fact in the sense of he had to determine whether or not there was probable cause behind the state's narrative of guilt, this second-degree murder charge against this officer, before he would allow the matter to proceed to trial. But the threshold, the judge said, for probable cause is so low that I think we have an unjust result here. Now, it is possible. So we do have to be careful. It is possible for there to be cases where there's contested evidence, contradictory evidence, ambiguous evidence. And so it's it's hard to know what the true story is. And when you have that kind of conflicting evidence, different witnesses saying different things, forensics evidence that's inconsistent, you may want to go to a jury with that, because the jury is the ultimate finder of fact. They have to determine which of the witnesses comes across as more credible, and all those finder of fact functions that are the role of the jury. So I get it where the evidence is more ambiguous. A judge may be more inclined to proceed the matter to a jury, even where probable cause may not be 51%. But I find it particularly offensive to use such a low threshold of probable cause as they're doing here, when there is no ambiguity in the evidence. And here, there's really no ambiguity of the evidence. We'll see it when we step through the video in the members only portion of today's show. And by the way, folks, if you'd like to step through the video with us, it's easy to become a Law of Self-Defense member. Just the URL is right there in my name. Let's see. How do I stop this stupid? Here we go.